Brachers Bitesize Employment Law Update in partnership with Diversity HR. Before I get into any content or any introductions or any of the material today, could I just do a bit of a sense check for those of you who have been on our sessions before, if you know how, if you could put your hands up just so that I know you can hear me today and that I've not failed to press the right button. Good, I can see a few hands, so thank you for doing that. I will carry on. Okay, today we're going to look at an employment law update. We're going to have a quick refresher and reminder of where we're at with the employment bill, and we're going to look at some recent potentially useful and key cases that you might want to be aware of, or if they're of particular interest to you, you might want to go and do a bit of further looking at what they've said and where the law now sits in those particular areas. For those of you that haven't been before, my name is Colin Smith. I'm an employment lawyer and a partner here at Brachers. You will be able to access copies of the slides. They will be sent to you or made available to you after the session, and there is a recording of this should you wish to look back at anything, so that you don't have to try and scribble everything down as we go, because we do tend, as those of you that may have been before, I do tend to run through things at a fair pace in the half an hour that we have available, because I'm conscious that you have the opportunity to look back at it later if you wish to do so. Okay, so without further ado, we will look at what we're going to talk about today. Tribunal fees. Those of you with longer memories will remember that we never used to have them, then we did have them. They did have a dramatic impact on tribunal claims being brought. They were then challenged successfully by the unions as being, in effect, discriminatory and disproportionate. They were thrown out. The government never got round to reintroducing them. The Labour government, there was a rumour, were going to reintroduce them as part of the various rumours flying around about what the upcoming budget will and won't talk about. But they appear to have been rather categorically, let's say, quashed by the new Justice Secretary David Lammy, saying absolutely not. We are not going to be introducing tribunal fees anytime soon. So probably next year, we'll see. But watch this space. But at the moment, no plans to introduce tribunal fees. The employment bill. We've done various previous sessions on the employment bill, looking into the detail of the proposals and the various key different aspects of it. I don't intend to repeat all of that today. This is more a refresher and a reminder of where the thing is at and the progress it's making towards becoming actual laws you actually need to deal with and actually need to do something about preparing for, okay? Rather than, in effect, politics they go on about, we're going to introduce this bill. We are getting to the point where they might actually bring some of it into force and it will actually have some day-to-day effects. But as you'll see in a minute, timescales for it are still somewhat in the distance, certainly for some of the large, more headline items, okay? So where are we at? Well, we're almost there, in theory. We are aiming for the final, allegedly, House of Lords reading on the 28th of October. It's meant to be a formality. It's meant to get to a point where the House of Lords accepts the will of the House of Commons and accepts the Act in the form that is presented to it. But there are rumours that certain peers are going to continue to propose amendments to the bill and send it back to the Commons. So it may well have a little bit more of politicking to go through before we get to a final bill and the royal assent. But it is anticipated, let's say, to be now, between now and Christmas, that the bill will actually become the Act. Okay, so we will probably end up with the Employment Act 2025 at some point between now and Christmas. It is largely what we call an enabling act. And what that means is it's lacking in a lot of the key detail we're actually going to need to be able to tell you what the law is actually going to say in a number of the areas we're going to touch on in a minute, okay? And that's because it's an act that gives the government the power to make statutory instrument regulations in which all the detail sits, okay? And they're not ready yet. They're to be consulted upon, they're to be developed. The latest roadmap we have for when all of this is happening is from July, and so I can run through what it says, but whether it's still the current timeline, we will have to wait and see. If you want to go and look at it, there is a big document on the government website called Implementing the Employment Rights Bill. It sets out some detail on all the proposals. It sets out their, in theory, roadmap, but as I say, it's a little bit out of date because it's already backdated to July. In theory, when the bill becomes the act and it becomes law, what will come in with immediate effect at that time is a lot of the trade union related changes. So repealing minimum service levels for strikes, repealing a lot of the restrictions on trade unions, removing various trade union regulatory provisions that govern how trade unions have to operate, okay? But also simplifying industrial action notices, making it simpler for trade unions to take strike action and giving them greater protection when they do so. So interesting, but if not entirely unsurprising, that the Labour government is looking to bring in greater powers and greater protections for trade unions as one of the first steps in this new bill. They've then said they're going to consult on various elements, and this is the point about they're going to consult on the statutory instruments, the nitty-gritty detail of a number of the proposals that are going to be authorised by the Act. So, for example, the devil in the detail that we've always said is missing in terms of this light touch unfair dismissal process for a as yet undecided period of time will be consulted upon this autumn. We're going to consult on things like this new school staff negotiating body, which will only affect you if you're involved in the education sector, but will be quite important if you are, and the same with the adult social care sector. They're going to consult on the details of how these things are all going to work, but therefore we don't have any of them yet. Okay. They're also going to consult on a number of the more complex trade union measures, such as allowing electronic balloting for strike action, okay, and simplifying the trade union recognition processes through the Central Arbitration Committee. Now, these are not that common. Many of you may never have come across them, but they're going to make them easier, which means it's going to increase the likelihood that you will come across them. Importantly, they're also going to consult on union rights of access to the workforce, which include things like the right of access to your premises to come in and recruit and talk to your workforce, which again is going to be an interesting challenge for employers who aren't used to enabling that and managing that situation. And the big one, they're going to come in and consult on the fire and rehire rights and how they're going to work. So there's still quite a long way to go before we get actual final regulations, okay? And there's loads more. I won't go through all of it because it's all on the slides you can see, but there's further consultations on how they're going to regulate umbrella companies, on how they're going to implement bereavement leave, on how they're going to change the rights for pregnant workers to give them greater protection from dismissal, and in terms of what reasons you will be allowed to dismiss and not dismiss, because all the Act says is there will be greater protections within a remit, but the actual details are all going to be in these statutory instruments as and when we get them, and the devil in the detail was 0 hours contracts and the rights to be offered guaranteed hours and guaranteed contracts if you're working more than X hours per week. Again, it's all going to be devil in the detail of the statutory instruments, which are yet to come. What we then expect in force, actually law, from April next year at the moment, we shall see, but the government have said they intend to stick to the existing practice, let's say, of introducing new laws at 2 specific dates a year, currently April and normally October. So on that basis, it would normally either be April or it will probably then slip to October, we'll see. But they're going to obviously bring in the new collective redundancy penalties, doubling the maximum award from 90 days to 180. They're going to bring in day 1 paternity leave and unpaid parental leave rights. They're going to enhance whistleblowing protections, and they're going to bring in this Fair Work Agency body. Whether that will all happen by April, we shall see. The Fair Work Agency body is going to be this enforcement body that's looking at certain areas of law, including things like holiday pay compliance. Okay. Also, the changes to statutory sick pay, that's the removal of the lower earnings limit rather, and the introduction, or rather the removal of a 3-day waiting period. And again, various changes to balloting for strike action and voluntary gender pay gap plans. The requirement to do so won't come in until 2027. October 2026, Potentially the ban on fire and rehire, and we'll come back to that in a minute in terms of where that now sits and what it's going to look like. The regulations for the Fair Pay Agreement for social care, the procurement two-tier code. We'll come back to that in a moment as well, because I think it's something that's slightly slipping under the radar. Tipping laws and various things to do with, again, rights to join a trade union, strengthening rights of trade union access to workplaces and so on and so forth, bringing in this all reasonable steps to prevent sexual harassment, an enhancement on the current reasonable steps, okay, and the introduction of the obligation on employers to take, again, reasonable steps to stop third-party harassment of their employees, which is another increase in the protection against harassment for employees going forward, and again, more trade union protection. October, again, they anticipate the increase in tribunal limits, 3 months up to 6 months. At the moment, that is anticipated to dramatically increase the number of tribunal claims that the tribunal system is already breaking under the weight of, let's be honest, at the moment. So quite how they're going to do that, whether they're going to then find extra funding for the tribunal system to cope with that, we shall see. And then again, more trade union protections for trade union activities. But the biggies, the most important items that we have all talked about is day one unfair dismissal. At the moment, not until 2027. Compulsory gender pay gap reporting, not until 2027. Enhanced rights for pregnant workers, possibly not until 2027. And also things like protection for 0 hours contracts and so on, not until 2027. So quite a lot of the real heavy hitters in terms of the changes are still some way off. But if you are looking into 2026 and you are contemplating HR budgets, changes, what you're going to need to deal with all this, there are still quite a lot of changes you're going to need to be up to speed with and aware of and looking at in the first few months of next year, once we have finished these consultations and once we therefore are starting to get more detailed provisions in the forms of these statutory instruments that give us the detail from which you will need to develop practices, procedures, training, policies, etc. But at the moment, there's not a great deal you can effectively do until we have that detail. You'll also see there the collective redundancy threshold is going to go up. We're going to change at that point, but I'll come on to that again in a moment. And as you said, the other big one that's attracted a lot of attention, these guaranteed hours and guaranteed contracts for 0 hours people. Again, at the moment, not predicted until 2027. So you've got a bit of breathing space for a lot of the big heavy duty changes. Okay. Some of the stuff that I think has changed or slipped under the radar or hasn't quite drawn the attention. Fire and rehire has had a lot of attention. It's had attention from me in previous webinars, but it's changed to a material degree as it's gone through the process. It was originally a very strict ban on all hire and refire in order to change terms and conditions. It's now been pared back to a degree, not much of a degree in my opinion, because now it only applies where the change to terms and conditions being proposed is a restricted variation, or it's a dismissal of an employee to hire another employee to do terms, but the terms have got a restricted variation. In other words, take employee A, you change your terms, but you keep employee A, or you take employee A, you get rid of employee A, but you hire employee B on changed terms. It still falls within the same test. The problem is the restricted variations are still incredibly wide. So the test that will apply will still apply in a significant number of cases where you are looking to change terms and conditions or potentially looking to have to do it by way of fire and rehire, because they're the controversial changes you're unlikely to get agreement to. For example, changing pay, changing hours, changing shift patterns, changing any kind of entitlement to time off, putting a clause in that enables you to unilaterally change any of those things as a way of trying to get around it. And anything else they decide to put in the regulations by 2027 when they bring this in, or 2026 they may bring this one in. Okay, so there's still a lot of stuff that most hire and fire processes will be trying to achieve. You are not allowed to achieve unless you meet the new threshold for being allowed to do so, and that threshold is a very, very high bar still. So the threshold is that you will still, if it's a restricted variation, you will still have to prove that the change is necessary to, in effect, tackle or alleviate serious financial difficulties that are likely to affect the ability to run the business as a going concern. We don't know how the courts are going to interpret that. We don't know how far they're going to take that. We don't know if it's going to be you're going to need to prove you are going bust, or how soon you are going bust, or what evidence you're going to need to bring forward to persuade the tribunal of that. It's all going to be uncharted waters, unfortunately, but you will also have to prove it could not reasonably have been avoided. And we have no idea how they're going to interpret that. It's taking the tribunals into new territory of judging commercial decisions in how a business is run and should be run. So it really is going to be unknown outcomes for that, unfortunately. And there's also up there, it's a slightly different worded test, obviously, for public sector authorities, which don't technically go bust, as it were. They simply run out of being sustainable and go into a specific procedure. Okay. There is also then going to be a slightly amended test for normal unfair dismissal. In other words, if you make changes that aren't a restricted variation, but they are still changes to terms and conditions that fall within this different test, it won't be automatically unfair, but there will still be a slightly different unfair dismissal assessment that will take place when you are doing these changes. And that is that, in effect, they will take into account the extent of the consultation you carried out and what alternatives you offered. Now, that's not hugely different to what normal unfair dismissal would do already, but the sting in the tail is the last bit, which says, as well as anything else they might specify in regulations. And again, we don't know what the regulations are going to throw in as further criteria that they're going to need to take into account. Replacement with non-employees. Now, this is a new provision that wasn't in the original bill, and it makes it automatically unfair to dismiss an employee, but the reason or principal reason is to enable the employer to replace the employee with an individual who is not an employee. In other words, take employees and replace them with self-employed or agency or contractors, where, critical word, the activities carried out by replacement are the same or substantially the same as those that were carried out by the employee, and in effect it's not a redundancy situation, which is a little incongruous because you wouldn't be replacing them with somebody if you didn't need the work doing. So I struggle in my head at the moment to conceptualize when that would apply, in which case it basically says, unless you are in serious financial difficulties, which is the same sort of test as we've just seen for fire and rehire, you won't be able to get rid of an employee and replace them with a non-employee doing the same work. And that represents a major limitation on how how employers will be able to choose to run their businesses. Collective redundancies, just to whistle-stop tour through this, the original proposal was to remove the requirement for redundancies to be at one establishment, which would mean it's across the whole employer that you're proposing 20 or more or 100 or more redundancies. It would have increased substantially the complexity of judging when you meet the threshold for a collective redundancy process. That was abandoned because it was too difficult, maybe it was too onerous. What they have said is that they may have a group-wide or a business-wide threshold that's higher than the current threshold. It might even be a percentage of the whole workforce, but it'll all be set out in regulations, so watch this space. We'll have to wait and see how that's going to wash out. And the only other headline that I would point out is the Employment Rights Bill says it's going to amend the Procurement Act to ensure that when public services are outsourced, question mark which public services, the contractor's direct employees, question mark what's a direct employee going to be, are not treated less favourably than those coming out of the public sector or vice versa. In other words, they're going to try and tackle two-tier workforces working on outsourced public sector work, but it's unclear to whom that will apply within the outsourced provider, but it could have significant cost implications for outsourced providers if you bring in 2 people from the public sector to work alongside 20 of your own people, and you've suddenly got to enhance all of the pay and benefits of your 20 people so that they're not less favourable than those that have come out of the public sector. That's going to have a major cost implication. So watch this space on that one. Right, that was a whistle-stop tour of where we are on the Employment Rights Bill and where we think we're going to go in terms of the future development of it. I just want to run through a few recent key cases. The first one with Christmas, not that far away, I hate to tell you that, but we're almost at the end of October, we're coming up to Halloween, and then it will be almost Christmas season upon us, I'm afraid. Liability for discrimination, meaning of in the course of employment. Now, what we mean here is, obviously, if somebody commits an act of discrimination or harassment at work in the office, it's normally fairly clear it's in the course of employment, but not always. But obviously, then there are always these work adjacent scenarios, particularly at this time of year that's coming up, drinks after work, Christmas parties, etc. And this case is a useful reminder of what the test is in terms of the meaning of in the course of employment. Under Section 109 of the Equality Act, if an act of discrimination is carried out by an employee in the course of their employment, the employer is secondarily liable, or what is sometimes referred to as vicariously liable, albeit technically that's a concept from a different concept of law, okay? And there's always been a bit of a debate about what is the correct test. Is it vicarious liability from, say, personal injury law, the law of tort, or is the test under discrimination its own test, okay? And what the law says is, if anything done by person A in the course of their employment is also treated as done by the employer, doesn't matter whether the employer approved it or knew about it. So if one of your employees in the course of their employment commits an act of discrimination, you're liable. Okay. There is then a defence, not on the slide, which is if you took all reasonable steps to prevent them doing that thing or a thing of that nature. But I won't have time to go into that now. Okay. The question is, what does in the course of employment mean? Traditionally in tort law, say personal injury type claims, the test is whether it was an unauthorised act or whether it was so connected with what he was employed to do as to be a mode of doing it. In other words, was it something that was so outside of what they're paid to do that you can't call it something that's sufficiently connected and therefore just an unauthorised way of doing something that is their job, okay? The discrimination test is a bit easier. What this case said, and it reiterated from the previous case law, is discrimination law should be given a broad interpretation, okay? And the concept of an act being done in the course of employment shouldn't be construed in a more limited way than the natural meaning of those words would convey. So basically they're saying, you look at it and go, in the ordinary course of employment means what those words would normally mean. Right. Thank you for that. What they said is tribunals are free and indeed bound to interpret the ordinary and readily understandable words in the course of the employment in the sense in which every layman will understand them. What I then accept is that not every layman would always understand them in the same sense, but ultimately what they're saying is we're not going to put any great layers on this. We're going to leave it up to tribunals in each case to decide what's in the ordinary course of employment. Great, thank you for that. But it's not the same test you have in tort of unauthorised ways of doing authorised things. It's just, was it done in the course of employment? And that will be for the tribunal to decide as a question of fact in each case. To give you some ideas or some cases that this case actually referenced, in Waters, Court of Appeal had to consider whether a sexual assault committed by a police officer against a colleague at a police section house where they had a room, where the victim had a room, and they were both off duty, was in the course of employment. Tribunal in that case said no, it wasn't, and the appeal tribunal agreed, and I can see the sense in that. That was not in the course of their employment. It was employment adjacent, but not close enough. Different case, again the police, unfortunately. A female police officer was sexually harassed by a male colleague at a pub where they had gathered socially after the conclusion of their duties. Okay? And the tribunal considered the social gathering was closely connected to work and that therefore the conduct was done in the course of employment. It's a very fine line, but it gives you an idea of how far discrimination protection can extend to work adjacent events, and particularly with the time of year we have coming up. It's just worth being aware of that. We don't want to be Christmas killjoys, but we do need to remind people that if they're going for drinks, if they're going for a team outing, if they're going for a team meal or a team event, these are all work events as far as discrimination law and standards of behaviour are concerned. Okay. Briefly, Stedman, this was a case that just made an interesting comment. Mr. Stedman had diagnosis of autism spectrum disorder and ADHD. He applied for a job, he didn't get it, he brought a discrimination claim. That's not what it's about. It's about comments that the EAT made about whether he was or was not a disabled person in law. Okay? And what normally you have to do as a disabled person bringing a claim is you quite often get put to proof that you're disabled, and that means producing medical evidence that says you have a medical condition, but also often an impact statement that says this medical condition has this impact on my normal day-to-day activities. And quite often claimants are not very good at doing both. Okay. What the EAT, the Employment Appeal Tribunal, said in this case, albeit obiter, so not technically binding, is they did say that there could be cases where a clinical diagnosis of ADHD or autism could be evidence not only that they have the medical condition, the impairment, but that it also meets the test for substantial adverse impact on normal day-to-day activities. Because a clinical diagnosis of that type means that they've been judged by a clinician to have significant difficulties with areas of functioning which are likely to impact normal day-to-day activities. So it could be an indication that it's going to be easier for claimants to establish they're disabled going forward. If you deal with travel time, if you have employees who are close to national minimum wage, who have significant work-related travel time, do be aware of this case of called Taylor's Services and HM Revenue and Customs. It was poultry workers that were collected from their homes and transported to sites where they did the work. But sometimes this could be extreme, up to 4 hours each way travel before they technically started work. Okay. HM Revenue and Customs said, we think that's for national minimum wage purposes time work, and therefore you should be paying the national minimum wage for that travel time. The company said no, it's not, and they challenged that assessment in the tribunal as they're entitled to do so. It went to the EAT because the tribunal said it is time work, you've got to pay national minimum wage. It goes up to the EAT who said no, it isn't time work, because in this case, this is not time they would otherwise have been working, and they weren't travelling from a place of work to another place of work. They were being collected, albeit in a company minibus, from their homes and shipped to where they were doing the work, and then collected and shipped home, not back to a place of work. It's a very fine distinction, but what they did sort of say is if they had gone to, say, a work site to be collected and then shipped, the outcome would have probably been different. The national minimum wage would have been payable, but because they were being collected at home, it wasn't. Even though the EAT didn't like that fine line, they felt it wasn't for them to determine the law any differently to how it stood. So if you are dealing with travel time cases, have a look at that one and just see what it has to say, because it's quite a useful one. Last one on unfair dismissal, because I'm conscious we're getting to the end of our time today. This is quite a useful one. We very rarely get appeal level decisions on just unfair dismissal these days, so it's quite helpful when we do. This one was about whether flaws in a broad disciplinary process, such as procedural imperfections or unpursued allegations, rendered the core dismissal unfair if the core allegations were fairly handled. In other words, let's say you had 5 different charges on the sheet, 2 of them have been dealt with inappropriately or unfairly, but you were only fired for the other 3 that were dealt with fairly. Is it still a process that's brought down by the unfairness in the ones that weren't the reason you got fired? Okay. To put that in context, what Mr. Allen argued is he faced an investigation into various accusations. Only 2 actually went to the disciplinary hearing, that he'd sent a harassing anonymous email, that he breached confidentiality by referencing findings from a separate investigation. So they started the process and they investigated a wider spectrum of claims, but when they got to the hearing, they were only dealing with these specific 2 claims. Okay. He was dismissed for gross misconduct. He brought claims of unfair dismissal and also separately race discrimination. He lost at the Employment Tribunal and he appealed. The EAT made the following key points. He argued the investigation was flawed because he wasn't given full transcripts of the investigatory interviews. But what the EAT rightly pointed out is didn't affect the fairness of what he was dismissed for, because those transcripts that he wasn't given related to the wider allegations that were not pursued. So there was no unfairness. Seems perfectly logical. You wonder why the ET couldn't see that. Yeah. Mr. Allen had sufficient information about what he was actually disciplined for, which is the key issue. Do you understand and have the evidence to respond to what you're actually being accused of? Not by that point what he wasn't being accused of. Okay. Interestingly, also for this audience, the decision maker had a script provided by HR for the meeting, but they critically found that whilst they had a script, they hadn't just robotically used it, they hadn't just rubber stamped it, and therefore just the existence of the script wasn't evidence that it was predetermined or that the decision maker wasn't making their own decision. Be careful with scripts, but that's useful if you do, because they are used quite a bit. Okay. And lastly, some evidence during the investigation could potentially be obtained in breach of his Article 8 rights, his right to privacy. I think it was certain emails. Okay. But that wasn't material that was then relied upon in the hearing, and therefore it had no bearing on the dismissal's fairness or unfairness. So what they said is, yeah, they might have gone off on a bit of a digging that they shouldn't have done over here, but in the end, it didn't make any difference because it wasn't actually evidence that was taken forward and used. So as a result, what they said is that what was actually done was fair, and what was unfair wasn't taken forward, and therefore didn't taint the fairness of the actual dismissal that took place. So it's quite useful because we do sometimes, let's say, have elements of a process that are not as good as they should be. As long as the bits you are relying on are done properly, the bits that aren't shouldn't bring you down from an unfair dismissal point of view. Okay. I'm conscious of time and I'm about 2 minutes over, so apologies for that. That brings an end to today's whistle-stop tour of where we are on the Employment Rights Bill, on the key developments and on some recent key cases. Thank you for coming today. I do appreciate the people that come and attend these sessions. We do take some pride in people coming along and hopefully taking some benefit from them. The next one we're going to look at is a session on grievances in the age of ChatGPT. It could just be us as employment lawyers, but we are seeing significant growth, not only in the volume, but in the scale and simply number of pages of grievances. So we're going to have a look at what, if anything, employers can do to try and tackle and address a growing prevalence of using AI products to generate complaints, letters, and in particular grievances, and how far you have to go to try and deal with those situations. I can just see I've got a couple of questions. The date for that, I don't know what the date for that is off the top of my head, but it's normally the second Tuesday in November, but we will double check and make sure that's known when we send stuff out to people. So thank you for coming today. It is appreciated, and I hope you have a good rest of your Tuesday.